celebrated at Christmas as Easter.
All right.
Happy Christmas to you.
Yeah,
I am John from Broadsheet, and this is the 15th in a series of shows on the Mother and Baby Home Commission of Investigation report. We're joined, as ever, very grateful to be joined by Breda Murphy, Tune campaigner, adoptee advocate and activist Union Duffy, and lawyer Frank Brownlee, whose father was a Tune adoptee. Good evening, Breda, Frank, and Union.
Hi. Evening, John.
We were going to talk about the vaccine trials in the Mother and Baby Home Commission of Investigation report. And there was nothing really new or that we didn't know the report discovered. Union, what's happened since then regarding the main people in it? It's GlaxoSmithKline, is that right?
Yes, GlaxoSmithKline. Yes, that's the descendant of the original Glaxo Laboratories and Wellcome Burroughs Foundation. So that was a split foundation which merged into GlaxoSmithKline, John, in the more recent years. So they've been highly involved in a number of trials worldwide, obviously, but obviously they had an involvement with a number of trials within the Commission's report on the remit. I think the Commission, if I remember rightly, the remit was 1922 to 1998, and found that there was 13 trials carried out within that period, and 7 of the institutions, I think it was, that carried out some of these trials that included Bessborough and Palletstown. So yeah, there was milk trials, etc., on the back of a number of diphtheria trials, polio trials, etc., that happened in that period of time.
And the Commission say that there's no evidence that any children were injured in those trials.
Yeah, well, how they can make that statement is beyond belief, really. And
because they did no follow-up.
Yeah, well, there was absolutely no follow-up. So how can you tell what the reactions are and what any potential repercussions there would have been health-wise and everything else, you know what I mean? Because of that, it's absolutely incredible to come out with that sweeping statement. Obviously, yeah.
And then Roderick O'Gorman wrote to GSK.
Yes, he wrote to GSK, and we just got news this week that basically they were not going to make any sort of a contribution towards any sort of financial redress, which of course would mean that they would, in doing so, they would accept some responsibility for the trials that carried out. So they've obviously washed their hands of the whole episode, but I think they'll probably, we know that there's a number of civil litigation cases going into them on the back of this, and we know there'll probably be more following on from that, because they've obviously denied any responsibility and accountability for what happened.
Yeah, sorry, you broke up there. Can you repeat the last sentence?
Yeah, well, basically, there'll be a number of civil litigation cases have already started towards GSK themselves, and there'll likely be a lot more on the back of that, John, because the Commission obviously has, and the Irish government have basically washed their hands of any kind of responsibility or accountability, or trying to put GSK under any kind of pressure in making contributions towards the financial redress, which is incredible, but absolutely not surprising given what the Commission and the Irish government have done in recent months and years.
If there's no liability, or if the Commission say there is nobody injured in these trials, you're saying that there are victims.
Well, there are absolutely victims. They have done some research on the issues. For example, they found in the 1930s, I just had a look today, and they said that I suppose the go-to thing back in the last 40, 50, 60 years was to be going after, there's actually a statement, I'm trying to find it here. Just give a wee second. Yes.
Yeah,
there was an RTE documentary done in 2018, RTE's prime time, and said that the babies were mostly taken from children's residential institutions, including mother and babies. Hundreds of bodies of dead babies were sent to the homes, to the Irish medical colleges, etc., etc. But it said at one point, it said it was much easier for research to do research on a captive population, where you've got all the subjects you might want for the study, all there in the one place. So Patrick Meenan, one of the leaders of the studies, justified his choice of study participants as there was, to quote, a tradition of doing testing in orphanages. So you went where the material was, to put it crudely. I have a personal involvement in this, obviously given my own circumstances and the knowledge that a number of trials were carried out over decades in Ireland. Given my own circumstances, I wanted to ask, because I quickly, very quickly found out that there were trials carried out here in the north of Ireland in the 60s. But the recent academic report by the academics here, they found no evidence of that. But I have correspondence from GSK directly from 2018, because I made a request for information to see if either myself or my birth mother had been involved in any trials in Marionville and Newry. And after about 5 months of being given the runaround between England, Dublin, and other parts of Ireland, they eventually come back after, first of all, thinking that the north of Ireland was part of the south of Ireland, and that the commission in the south was covering the north of Ireland. I had to correct them on that. They eventually get back to me and they said to me that, I'll just read it out.
Sure.
Mr. Duffy, we have now completed an exhaustive search in light of what our safety department provided us. The trials in the attached document are from the last trials undertaken by Glaxo in the UK. You will note that the last trial in Northern Ireland was that started in August 1967 under a Dr. James McKinney. McKinney was the medical officer for the health of in County Down at the time. The trial does not appear to have been published, but was designed to test reactions in patients from 2 already established vaccinations on the market. Now, bearing in mind that your date of birth in 1968, and appreciating the usual short time frame for these type of trials, but accepting potential follow-up, it is highly unlikely that you could have been involved in this trial. Irrespective, as the trial was not published, we cannot comment on matters such as consent, other than the fact that the usual procedure would be for the investigator to seek consent from either the relative and or those in charge of the homes. And I cannot provide any more information that might be helpful to you. So what they're trying to say is that it's highly unlikely that me or my birth mother would have been involved in these trials because they weren't published, which is absolutely nonsense. So I actually looked up, I found this Dr. McKinney in a medical register of 1965 and 1967. I have proof from GlaxoSmithKline themselves, who sent me the documentation that clearly shows that these trials were carried out. And they're listed here, some of the trials that were carried out in the south of Ireland as well, one of which I cannot find in the Commission's report.
Really?
So I don't know if it's because they couldn't find it or they didn't include it.
Or it wasn't published, as you say.
Or it wasn't published. But contrary to what they told me about trials not being published, in November of 1965, there was research published by a Professor Alan Dick from Ballymena. James McKinney was obviously involved in the trials in 1967. There was another trial in June 1966 in County Tyrone by a Dr. Swan to test the efficacy of multiple puncture BCG vaccine given by a March 6 East gum, whatever that means. But the relevance is, John, that as a baby, according to my records, in November 1968, a few weeks after I was born, blood tests were carried out on me on what was called a Wassermann test and Price's precipitation reaction. Now, I looked that up, and that's a syphilis test
Jeez.
Same way.
that I was given as a baby. Now, my birth mother was in that institution from April that year. So certainly looks to me that there's a good possibility I was given some kind of an experimental drug to test me, to see whether I had syphilis or something like it. Now, birth mothers have told me, and it's widely known, that a lot of birth mothers, when entering these institutions, were given syphilis tests nearly straight away in some cases. So why they were given to me 5 months after my birth mother entered the institution, I don't know. But it certainly highlights, a lot of discrepancies, unanswered questions that we've been facing on countless issues, Joe.
And the one that wasn't, that you haven't sort of seen recorded in the South, the one that they mentioned, but you couldn't find a record of in the South.
Oh yes, yeah. Now there's no record of that same kind of a trial being carried out here, but
right.
There's, yes. Where is it? Yes,
Sorry,
it's a trial carried out by Dr. Hillary.
Irene Hillary, yeah.
Yes, and how long did I say?
She was UCD, I think. No, she was a lecturer in microbiology at UCD.
How long did I say here?
No problem.
If you just want to go to Brady or Frank there, I
just want to share the letter from GlaxoSmithKline.
Oh, sorry, I have it here. So,
okay.
Dr. Hillary, May 1966, the comparison of multiple and water in oil influenza vaccine. That is not recorded in the Commission's report because I've already checked.
Fascinating, because I think how they found out about these, or certainly we did when we were doing our research, is that they were published. They have to be published for them to be peer reviewed, I guess, isn't that? Is that it, Frank? Or
yeah, it would be the case that if if it's an open research module, funded by governments or stuff like that, then it would have to, if it's going to be used globally, it would have to be, like any scientific research, would have to be peer reviewed. Yeah.
So they must, that's their loophole. If studies weren't published, presumably they weren't published if they're not a success, and that would involve, anyway.
It could also be because there are elements within a medicine, say for example, that's being used that has commercial sensitivity, it has proprietary rights, intellectual property, right. Even going way back when, that would be a consideration or a factor in that. And I suspect if it is probably the more controversial a medicine would be, probably the greater the sensitivity there would be to protect that intellectual property right.
Yeah.
It's a bit of an abstract argument when you're dealing,
totally, yeah,
in the way that Eunan's talking. Yeah.
I mean, it doesn't matter to the children whether it's published or not. And in terms of, do you think we'll discover more? I mean, you found one. Does it say which institution that was?
No, that's all the information it gives, John. Just May 1966, and it was a water in oil influenza vaccine. I checked that with the trials that the Commission had reported.
Yeah.
The Commission's report in the south of Ireland, and there's no mention of it at all.
No.
But the Commission did say that in a lot of cases, there's no evidence that any attempt was made to seek consent of the mothers of the milk trials, for example. And those milk trials, actually, interestingly as well, they were outside the actual remit of the Commission in the fact that they wouldn't be technically considered a vaccine trial because it was a milk trial. But right. they did investigate two milk trials in the late 1960s in Bessborough and Palletstown because they came within the terms of reference. And
can you explain what a milk trial is?
Well, it's basically, I suppose, the powdered milk that Alexa GlaxoSmithKline at that time would have been bringing into the institutions to try them out. And I did find some of the things that it refers to here now. This is 1969, the overseas milk powders that were brought in. Now, the commission actually, in some cases, seen that there was consideration by GlaxoSmithKline to apply for a license for those powders to be imported into Republic, but there was no evidence that the license was actually granted, which means that they were legally brought in and they were trialed out in the institutions. It also said that the trial protocol, this is in page 2076, the trial protocol calls for the inclusion of 40 infants in both institutions. This was Palestine and Westborough. Stipulated that the mother's house name would be recorded as the only identifying factor on the documentation relating to the trial. It also said that because of the passage of time, the records are very difficult to read, and this did not assist the Commission's efforts to identify the children involved in the milk trials. It goes on to say later in a few paragraphs down, Palestine, infants in Palestine experience vomiting, regurgitation, irritability, and green stools. In 2 instances, infants experience violent vomiting in reactions to the feed, and these children were subsequently withdrawn from the trial. It also said it is not clear that the milk trials constituted clinical trials within the meaning of the Therapeutic Substances Act of 1932, so it is not clear if any import license or a research license was required.
Right. Thanks, Ian. Can I just share the letter from GSK to Roderick O'Gorman, who's the Minister for Children, and oversees this. Just to they named the names. The records we shared with the Commission showed that the trials were conducted by a number of experienced medical researchers. Professor Patrick Meenan at UCD, the late Dr. Irene Hillary. I think Professor Meenan is dead, isn't he? Breda is.
Yes.
Yeah. So he's the late and head of the university's Dr. Irene Hillary, the late Dr. Victoria Coffey, a pediatrician and lecturer at Trinity, and the late Margaret Dunleavy, a medical researcher and public health doctor. To add to that, you have your guy in Northern Ireland Union. What's his name? The guy Keenan.
Yeah, well, no, there was actually 3 different professors. There was a Professor Swan, a Professor Dick, and a Professor James McKinney, who all carried out trials between 65 and 67 in 2 different counties. Okay. But they say that these trials aren't published.
Are they?
So that means that nobody would have been experimented on.
Are they still alive, those guys?
I would doubt it, John. I checked them on the medical register, and them guys were all sort of born around the start of the 20th century.
Yeah.
In the 1930s, but it seems like they have sons and daughters who've went on into the profession as well. But yeah. I've sent in a variety of FOIs to the General Medical Council, pharmaceutical bodies, including GSK, to try and get some further disclosure and information on these trials, and they've all come back with nothing on them. So
I'll just go back to the letter, Ian, and just despite each of the trials described in the report was bona fide and undertaken for the purpose of legitimate medical and scientific investigation into improvements to essential childhood vaccines, and in one trial, infant milk products. Importantly, the report concluded no adverse injuries were experienced by the children involved in these trials. Which is pretty astonishing, really, to think they can actually write that. You know, I mean, it's an insult, isn't it? I mean,
and those trials, John, have been discussed for over 2 decades in Dáil Éireann. Micheál Martin, when he was Minister for Health, he wanted, it was then Judge Lafoy, to look into the vaccine trials. And he commissioned the Chief Medical Officer, who was Dr. James Kiley, to look into them. And then Judge Laffoy stepped down due to the fact that she wasn't able to access the material that she needed. And Judge Ryan stepped up. But when you look at the contributions in Dáil Éireann at that time, and granted, Micheál Martin, today's Taoiseach, was then Minister for Health, he was adamant that this was the beginning of a process. You know, this was not the end. They were going to find out much more about these trials. We're 21 years on, and that same minister is now Taoiseach. And what we have got in the Commission's report, granted, it did not really look into the vaccine trials. I think what we need is a forensic investigation, and we need all of the documentary evidence to be seized. And regardless of where it is, I mean, many of, I said this before about Tuam, when in the Tuam home they held meetings, that is the councillors, they often went home after a meeting in those years, and they would have lived in the surrounding areas. And many people may have brought home notes with them, or may have had files within their homes. And because so much documentation is missing, I would ask the families of those doctors that are mentioned and professors to please, you know, look into their own records and archives and attics to see what may be there that may help a family, because it's impossible to say that no child had a long-term adverse effect. Or, you know, there's another argument that is where so many children have passed away without an inquest being carried out. You cannot say for definite.
No.
You know, and that's why we need the coroner's involvement.
They obviously have some records, Breda, don't they? Because they write, we are, however, aware that many former residents are understandably seeking to access their personal information on these events. As the holders of records from these clinical trials, we've reflected on how we may be able to improve and expedite. So they have loads of information on these trials.
They have, and Mary Steed has taken the judicial review. So, you know, and she needed to do that, and she's named the minister and the government, the state in that. You see, the commission and the commissioners should have come before the Oireachtas, in my view. Now, I know we've talked about this before, but I think they had an obligation to come, a moral obligation, because the investigation was carried out. And our survivors who would have been in a mother and baby home, many of them went on to be in a residential unit like the industrial schools. So they may have had vaccines on separate occasions, you know, throughout their youth, you know, up until the age of 10 or whatever. And there is a right to information. And there's a professor of immunology and cell biology, I think. His name is Bernard Mahan, and he's in Maynooth. And he makes the statement that the commission to make these allegations, to say that there is no adverse effects found in the children, that has not. He makes the point that, you know, it has not been looked into enough, so that if it were, perhaps we would get more information.
Yeah, has it been at all? Has anybody attempted to do any follow-up to find these? I mean, the commission just accepted their word. I mean, GlaxoSmithKline's word on this.
Well, I think it's early days as regards, you know, getting the correspondence back from Glaxo, but I think there will be more about this. But absolutely, there has to be a forensic investigation. And I don't know, I mean, maybe Frank could talk about the type of investigation that would need to be carried out with a very clear human rights element to it, because the rights of the children, the rights of the mothers, and there is no evidence that consent was given. And even if the sisters themselves were acting as local parentheses, they had a duty equally to the well-being of the child. And when you read some of what Ewan has read out, you know, violent illness or sickness or vomiting. I mean, that is putting a child of a few months or a few years under their body under severe trauma. And the long-term consequences of that, they might not come out for a few years. It may be well after, but they were never followed up. And that seems to be very clear to me. So if I were in a mother and baby home, and I would say to many people who were, look seriously at taking an action, because the government have failed you again. And this Commission's report is absolutely a whitewash, but it's always interesting to go back to what Micheál Martin would have said 21 years ago, and Rabbitte would have said when she was in opposition, you know, with regard to the coroner asking the minister, who was then Catherine Sapone, you know, I think that's what exposes the dishonesty that is in politics. It's a tough game, I know it is, but you know, there has to be honesty. And these children were the most vulnerable in Irish society. And Professor Meehan's remarks there were callous, you know, to say that this is, you go where the material is, you know, so you take in, you know, 20 children into a room and you inject them. I know I'm judging today,
No.
but even then, to think that, you know, that the sisters would allow a child to be injected. It's the same as Tuam. When the nuns in the 5th interim report, and it was a fairly hefty report, there was a lot of forensic evidence and appendices, and the suggestion was that where the children's remains are was actually a crypt. And so the state went in to make sure, you know, that this was to really identify what it was. Now, my view was, if that was a crypt, the first people to be placed there were their own sisters who died during the same period. And because they weren't treated in the same way, and the children were disposed of in underground chambers, it showed very clearly that there was no regard for them. And it's the same, absolutely the same thing with regard to vaccine trials. It is completely dishonest, and I think the government need to be challenged, and preferably by an external organisation outside of Ireland who will say this is unacceptable on behalf of the children who suffered. So yeah, Frank will probably know more than as to how.
I was just going to Frank. Vaccines in Ireland it's a huge business. 64% of our exports were pharmaceuticals, of which the majority were vaccines. So we're financially committed or sort of entwined with these organisations, and which might explain the hands-off approach by the Commission, and even Roderick Gorman's letter to them. There's 2 universities involved, though. You've got UCD and Trinity College Dublin. What's the potential there in terms of for legal action for either?
Well, pharma is big business. It's bigger than airlines and various other industries around the planet. And what is interesting listening to this conversation is that there is a global trend for medical experimentation, using minorities, using people who are vulnerable. It struck me, for example, when Eunan was talking about syphilis, there's a big issue in relation to syphilis medication trials in the United States involving African-American men, and that delivered terrible consequences. Equally, polio delivered, I think it was 1955, it delivered quite a large number of paralysis in those who received the experimental vaccine at the time. And so you know, you can see the vulnerability aspect of it, you know, particularly in Canada, for example, where children of Canadian Indians from the various tribes were experimented upon. You also see it in Australia as well with Aboriginal children. So, you know, this is this is quite a big issue in terms of the actual practice of vaccine trials or medical trials, and the business that is pharma and the business that is government. And what I would say, and I will come to your question about the potential for legal action, but in my opinion, out of everything that is in the Mother and Baby Home Commission report, this is the biggest example of the abdication of legal minds who were involved in this report, in the construction of this report. By their own words, they demonstrated that the vaccine trials didn't even meet regulatory or indeed standards at the time. They also acknowledged that consent had not been obtained. And I must admit, you probably saw me screwing my eyes up because I haven't got my glasses when I was reading that letter. And it was a very interesting paragraph there from GSK, basically where they kind of split two worlds. You know, the practice of consent as was, and of course the practice of consent as is today. And I don't hold in any of this whole Magdalene story, I do not hold with that was the time. I just don't hold with that at all. And I'm going to demonstrate to you why in this case, in the vaccine issues, it doesn't hold. So for example, the Mother and Baby Home report talks about Bessborough and what went on there. I think it was in 1961. So then you have to kind of look at the legality of all of this, because what is driving, what the thing that they fear most is the consent issue. And so therefore, is the second part of that paragraph in that letter correct, that, you know, we're working to different parameters today than we were in yesteryear? And the short answer to that is no. Because by the end of the 19th century into the 20th century, European society was ablaze with philosophers and jurists and politicians, new breeds of politicians, talking about the advent of human rights, the advent of a new political order. And in the midst of that, there was most certainly, as far as medical ethics was concerned, the rise of that discussion in ethic. And that was clearly seen in pre-war Germany, pre-World War II Germany, where the German Medical Association was highly respected because of its progressive and ethical approach to all issues of medical treatments, including medical trials. And it changed around the mid-1920s through the desire to create racial hygiene. And the rest is history, because from that point on, the German Medical Association came under pressure, like a lot of elements in German society. And German politics created the conditions for what we all now know and understand. So then you move forward to 1947, and the doctor's trial in Nuremberg, USA versus Brandt, actually highlighted the unethicality, if you like, of what had taken place, and how on earth did we get to that particular point. And that resulted in the creation of the Nuremberg Code. And this codex, it basically is a 10-point plan. If you're going to carry out medical experiments, this is what you've got to do. And at the top of that list, guess what? It's all about voluntary consent. That was in 1947, okay? And bearing in mind, there was that was already in existence pre-war in Germany. So it was obviously a factor within Europe itself as a whole, that consent was an important factor if you were doing this thing. But then it goes further, because by 1964, you have what's called the Declaration of Helsinki. And Article 8 introduces and formalizes the right to self-determination. In other words, consent. And it was America, actually, and this comes to the pharma point, America, because it's gone through several iterations, and it was America who actually withdrew and stopped the use of the Declaration of Helsinki and created their own medical ethics code, which was deployed, I understand from what I've read, quite successfully by American pharma companies outside of America into places like Africa and so on. But you can even bring it right up to 2012, where you've got the Ottawa Statement. Okay.
Oh yeah.
The Ottawa Statement, which again, its primary focus is informed consent, particularly with what I call these, what we're talking about as cluster trials. The document talks about cluster randomized trials. But the key point here is, whatever about the GSK lesser, there was a standard that should have been deployed. It was a medical ethics standard. And it was, okay, say like the Declaration of Helsinki wasn't legally binding, but it was nonetheless incorporated into a number of legal systems. So you have that background, you have the GSK lesser, you have the Mother and Baby Home Report, which must surely know if pharma companies are delivering this kind of information, and the report concludes that we didn't even come up to the regulatory or other standards, presumably medical standards at the time, then the question has to be asked, well, how do we challenge that? Well, we have to do what I've done, what I've just done. I've just rehearsed basically a very brief history of informed consent in medical experiments. So then you asked me the question about about legal possibilities. Well, you know what? I have to go back in time again to 1932, and the UK and Ireland are common law jurisdictions. And there's a great case. I love this case. I wax lyrical about it. Donoghue and Stevenson, and it formally introduced the concept of duty of care, the neighbour principle. And essentially, if you're supplying a product, then you had better make sure it's not going to do any harm. And I'm really paraphrasing that case, but there are many developments since 1932 about remoteness of damage and stuff like that. But where you're dealing, say if you were dealing with a doctor would be held to the basic of a duty of care. But because he is professionally qualified, or she is professionally qualified, there is a higher standard again that must be deployed above the actual baseline of duty of care. So in any of the cases that are potentially going to be run, that's where they will start. Basically, did the farmer, did the government owe these children or mothers a duty of care? And I think the short answer to that question has to be yes. Then it follows, and did that breach of duty of care cause the medical conditions? Now, here's the problem for many of the victims and survivors, and Eunan alluded to it, which is, if you haven't got this information, if it's kind of shrouded in this kind of mystery, it potentially is difficult to prove that causation. But by their own words in the Commission's report, for example, and Eunan's touched on it, I think it was in Pelletstown, but they talk about the side effects, the vomiting and the diarrhea. Yeah. I mean, those are minor side effects, but what really, and this cuts to the heart of Breda's points, there really should be a very detailed examination, a medical examination of every single child and every single woman who has been through these institutions and has either been subject to or suspected to have been subjected to these trials. and a proper medical history obtained from each of the victims and survivors, so that we can determine patterns. We can determine patterns of effects, and I think it's a bit of an uphill struggle. The biggest issue facing and GSK, and I'm not letting any cat out of the bag when I say this, is going to be disclosure or discovery. It depends what terminology is used. And it's almost akin, the problems are almost akin to the tobacco litigation or contaminated water type cases. And that is going to be where the challenge is. But
what is Union's position in British law, in English law? Is the same? Would it be the same?
Oh yeah, definitely. Yeah, I mean, I've been pretty close to kind of not vaccine medical trial cases, but I'm just trying to think of one that I can perhaps talk about. I dealt with a silicon oil case. It was a cosmetic case. And I actually trailed through, and I mean this, thousands of documents and several hard drives. And this is the Herculean task that faces any litigant's legal representatives. Now, we won that case because I rolled my sleeves up and we found the evidence that silicon oil can cause harm. But the difficulty, and that took years to get that documentation, but the difficulty is going to be getting that documentation that can open that particular door. And I'm sorry to be a gloomy bear about that, but I'd rather project the reality on that. But this
for
is.
instance, Frank, Union has just discovered that they omitted, whether deliberately or not.
Yeah, exactly. I mean, there is, and I suspect there's going to be many more people like Union who have, if you like, almost like a wedge in the door, so to speak, because from that, and that's exactly the way I deal with this.
Yeah.
I look for those wedges, and it's a series of questioning, it's a series of applications, and so on and so forth. But the key issue is, the point I was going to make here is that this mother and baby home report should be scrapped, quite honestly. It isn't really worth the paper it's written on, particularly when it produces this kind of commentary or lack of commentary. And what is at the centre of all of this? We can talk until we're blue in the face about pharma and various industries, but at the core of this is the Irish government, whichever political flag was flying over the Dáil at the time.
And the Irish medical establishment is
and the Irish medical establishment, because there are a number of potential defendants that future litigants could look at.
This is Meenan and Irene Hillary, by the way. Sorry.
Sure, no, it's no problem. Yeah. But it seems to me that this is of such important public interest. The Republic loves to cite the fact that it is very keen on human rights. And in fact, as I understand it, in order to get its temporary cease on the Security Council, it had to make commitments and demonstrate its commitment to human rights. And quite correctly so. But within the archives of the Irish Republic, there will be documentation for the victims and survivors. And within that documentation, there will be commercial documentation, and it will lift the lid. This, in my opinion, this is as a Herculean case as water contamination and tobacco litigation, because it is, and I mean this with very sincere respect. It's not just about the victims and survivors, but it's about the potential of passing on any issues, to your offspring, and how it affects future generations,
Crucial.
or indeed the present care of victims and survivors, and really.
For instance, if your father had been used on a trial, you would like to know that.
Well, yeah, I mean, oddly enough, in this past week, just before Easter, I'm reasonably satisfied he wasn't involved in a clinical trial. But yeah, no, that would be a very aching point for me. I would want to know. This is a huge legal failure.
Yeah, we don't do class action lawsuits in Ireland, sadly.
Say again?
We don't do class action lawsuits in Ireland, sadly. But
yes, but there's a nice piece of European regulation, which is part of the reason why the UK wanted to get out, which will introduce a very real possibility of class actions. It may already be in, as far as I know. And it is a piece of European regulation which the corporations really fear.
Yeah.
And it has the potential to join not just people within a district or a country, but across borders. And it is specifically designed for that, to help European citizens deal with the problems of large corporate bodies who operate across borders, or previous to the European Union, operated across borders. Doesn't matter what it is. So there is the potential there. And I will add as a footnote to that, if group actions aren't allowed in the Republic, then that has to be, in my opinion, and I'm just throwing this out there, that has to be a breach of Irish citizens' rights under Article 6 of the European Convention on the Right to a Fair Hearing, because I've run group actions and I know the value from group actions, and I know, and this is probably why they aren't currently being used in the Republic. But a group action is what commercial entities fear the most. I know, I've sat across the table from them.
Yeah.
And
it's very ineffective when there's like, a smattering of people rather than just the one voice.
And I mean, I can't pretend I know everything about Irish law, because I don't, but it does strike me as being a bit odd. There's Irish lawyers, and you can all come and beat me up afterwards, lads, but it does strike me as being a bit odd that if you have a category of potential claimants, that you don't make efforts to try and join them together before the courts, because the logic is that it doesn't matter where the court is, it could be in Paris, Dublin, or London.
No.
The court doesn't want to be littered up with 1,000 or 10,000 individual files. They want a group of people, logically, with test cases that will drive it through. So,
that would be a kind of victim-centered
absolutely, yeah. But I'll try and find out that European regulation. It kind of dropped off my radar, but it is an important one, I think, for going forward for this cohort of victims and survivors.
Union, or at least Breda, where do you start in terms of collating who might have been a victim? Who might be. Sorry.
I think if groups could see the the likelihood of it succeeding, I think that people would come together, because it's the best way of working. Not alone will you have people supporting one another from different groups, so it's peer support, and you'll have them exchanging information, but you'll attract legal minds that might not otherwise be involved at this point. It's interesting to note that when the Commission to Inquire into Child Abuse was proceeding the year 2000, that Professor Hillary challenged. And if I could read that out, it might be relevant. The Kiley report states that the Therapeutic Substances Act of 1932 was the statute governing the importation and the use of vaccines in these trials. It has not been possible to locate or identify documentation that would confirm whether or not the legal requirements of this Act complied with the respect of 3 trials that they'd looked at. Whatever the implications of the Therapeutic Substance Act for the lawfulness of the use of therapeutic substances in the state during the conduct of clinical trials, there was no legislation prescribing the procedure for conducting the trials, nor was there any legislation dealing with the issue of consent to participate in a clinical trial before the enactment of Control of Clinical Trials Act in 1987. In November 2000, the Minister for Health referred the Kiley report to the CICA because the most rigorous interrogation of the system failed to produce documentary records of the trials. The CICA set up a vaccine trials division which investigated the matter for 2 years. In June of 2004, however, as a result of a legal action taken by Professor Irene Hillery, the state's order to the CICA was held to be invalid by the High Court, and the CICA's work on the vaccine trials was halted. The judgment in Hillery versus Department of Education 2005 suggests that the researchers involved in the trials in question confirmed in a public statement on the 9th of July 1997 that the researchers had received the consent of some of the parents of the infants involved in the trial. It was recorded in the judgment that in subsequent communications, Professor Hillery asserted that she requested and received the permission of both the management and medical officer of the home in Besborough to carry out a trial, and that she understood that all the parents whose infants were participants were informed either by her or by the manager of the nature of the vaccination being undertaken, and they gave consent on that basis. So that's what you were up against then, you know, and today they will probably continue to challenge. But I think the Irish government, the duty to care, as Frank says, that is you know, the most important aspect of it. The children were so vulnerable, their parents, some parents were as young as, you know, 13, 14, 15.
Union, have you any way of establishing if your mother gave consent, or indeed if she was aware of any trials, in a position to?
Absolutely not, John. All they can basically go by is, you know, I've heard the testimonies of a number of birth mothers who have told me, for example, that when, as I said earlier, you know what I mean, a lot of them were given medical tests when they first went into the institution. The academic report up here cites the fact that a lot of women were given internal examinations by GPs at least twice a week for it seemed no apparent reason. You know what I mean? It just seemed to be a regular thing, you know, whether somebody was getting some kind of a kick out of it or whatever. But a number of birth mothers have told me as well that they were given medication on a daily basis and had no idea whatsoever what it was for.
Really?
So they weren't in a position to ask questions. They were given it. They were basically says, you know, take that for whatever reason. We do know that the Examiner, for example, in the South there reported, I think it was 2019, about a woman who came on who was there was an article done on her, I think she's called Philomena, somebody, about the phenobarbiturates that she was given on a daily basis as well. That was basically a sedative to try and relax her, but it had the opposite effect, I think it was. So, you know, the Commission's report as well in the last page of chapter 34 that I read today basically exonerated the religious institutions as well, because it said that the 3 doctors that had carried out the milk trials, for example, in Palletstown and Baseborough, basically had carried those trials out without any kind of consent or authority, even from the institutions themselves, never mind the mothers. And it basically, what it tried to say was that that the staff in the institution, the nuns or whoever, whether they were lay staff or what, didn't know that there was a milk trial going on. And it was only when the baby started to react in a really, really bad way that the institutions then found out, there's some kind of a trial going on here. I mean, if the Commission expect us to believe that, that's again another indicating example where they're trying to exonerate the religious institutions, and they're happy to put the blame on the 3 doctors who are in all likelihood now passed away and cannot face any kind of charges. So
Yeah.
again, it's this.
It's like Hillary and me, and yeah, they're that.
Look, John, we've seen that article that we found this week as well about America and the orphans. And again, the term orphan comes up on a regular basis here as well in terms of the narrative, because it suits a lot of people to say that the babies that were either experimented on, that were left to die, that were adopted out were orphans, that were migrated to Australia and Canada, etc. And they're called unaccompanied children. You know what I mean? This is a complete misnomer. It's very, very misleading as well, because, you know what I mean? It means that any child that basically didn't have a parent anywhere near an institution, in the institution at the same time, they were classed as orphans when they weren't actually orphans at all. So it's a complete get out. It's a complete cop out.
Yeah, of course. Yeah, they're not orphans. Yeah, of course they weren't.
Absolutely. You know what I mean? But, even that article we found by the Observer in England today about America, on GlaxoSmithKline and the 4 trials they carried out on the Hispanic and Black children there with the HIV drugs was exactly the same thing. So they were basically going into an institution, and because these children were so-called in cure and they were orphans, no consent was required.
Absolutely, yeah. It's like Mengele in the war. I mean, they literally pray for whatever they want to do with them. I mean, there's no comeback. There's no. I mean, perhaps a child has died from these.
Absolutely. But, in terms of the mother and baby institutions, for example, as well, the denial of breast milk, which is highly nutritious for any baby, that again was another issue here. And whether or not that was the deliberate ploy and a strategy for anyone that was being used in a clinical trial of some kind, an experiment, a drug, a vaccine trial, a milk trial, whatever the case was, was that part of the ploy? We'll deny the child the breast milk and try out the baby milk on them to see what the reaction is. And maybe would they compare that to a woman that was breastfeeding the baby? But of course, we know a number of birth mothers have testified to the fact that they had absolutely no relationship with their baby at all.
Yeah,
some birth mothers had to tend to the babies of other birth mothers when their own child had been taken off them. So, and again, there's extensive medical research, John, to say that any baby that suffers an early life separation is going to have all sorts of physical as well as psychological and emotional effects. And, for example, adoptees are well known for a propensity to develop all sorts of gastrointestinal disorders going forward in life. So these are absolutely massive issues that have been in many cases overlooked.
Well, thank you very much, Ian and Frank and Breda. Thanks. Anybody want to add anything just before we go?
I was just going to say, I don't want to malign dear old Ireland, but you do have group actions. I would have been surprised if you didn't. And they can be set up through the rules of the superior courts. They don't appear to happen very often. But nonetheless, there is a power there to create multi-plaintiff claimant actions, I should say, or plaintiff, and the EU, it's called the EU Representative Actions Directive, came into force in November last year. It's something I was monitoring for my other work.
So this is Irish law now, effectively.
Because effectively, if it's a directive, all countries have to implement it through their own legal system. So, and they had 20 days from publication in order to implement it. So I don't know whether the Republic has done that, but it's an interesting point, and I'll deal with it very quickly, because it is primarily a consumer-driven directive. So, for example, problems with cars and stuff like that. And it's an interesting point because I dealt with a blood contamination case, which was part of a very big group action. And there were a number of difficulties in establishing how to deal with the liability of the defendants in that case. And it was determined that one of the best ways to deal with the defendants was to make a claim under product liability laws. So therefore, if you had people who received contaminated blood products, and there was all sorts of other issues about that. And it was determined that it was a product. It's not too far a stretch to say that whatever was given to the children and the women was a product. Whether they were a willing consumer or not, it's still a product. So, I'm opening out a whole range of arguments here. Potential for group actions in the Republic, potential through the European directive for a consumer type product liability action, which is related to the medical conditions that potentially or potentially has affected people through their lives. So there's a great deal of stuff to do out there. But I think if it was me, if I was practicing in the Republic, I would be more inclined to be looking down the group action rather than individual cases.
Right. So prior to last year then, what was our position? There was no formal procedure for class action lawsuits, but there was you could have a test case, was it? Or something?
No, I mean, from what I can see, just look at it very quickly, the rules of the superior courts are going to be like the rules for the Supreme Court in England and Wales. And basically, they are a body of rules in whichever jurisdiction, legal jurisdiction, that sets out basically the rules of the court, but the rules of how lawyers and how claimants engage with those courts. So it doesn't give me the year here that the rules were in, but I suspect, because it's a common law jurisdiction, that rules of the superior courts have been in for some time, maybe in different iterations. But looking at this, I mean, this is a law review that I'm reading very quickly here, written by a couple of lawyers. It looks like class actions have been taken in the Republic. They don't appear to have been that popular, if that's the correct way to use it. It looks like they've been used in data protection, oddly enough, and GDPR actions, whatever they might amount to. I suspect those are probably commercial failures where, say, a company has been hacked and stuff like that.
Just on as multi-party litigation in Ireland may proceed by way of representative action or test case. There's no formal class action procedure in Ireland. A representative action arises, but is this just semantics then?
That is a bit of semantics, because if you've got the rules of the Superior Court, that's your base. That will dictate how they're created. It's a bit like, here you have to get a group litigation order, and you have to prove to the court that you are managing the case correctly, that there is a lead lawyer, and what kind of test cases are going to be presented. So it's all about case management more than anything. But the potential is definitely there.
That's great. And in terms of if we could perhaps ask people to, if they know of anybody, or if we could appeal to the survivor groups if any of their members are.
I think what I would quickly observe is that when you look at everything that Eunan has said and Breda has said, and my own observations, it's all about isolation, isn't it? Isolation of information, isolation of the individual, isolation, of families. And everybody is an island, effectively, and that's what I'm saying. Maybe I am being too critical of Irish lawyers, and I don't mean to be, but there are probably some there who are working towards a kind of a group or class action or a representative action kind of process. But I will say, in my last 10 years, 11 years of doing this, I've never had the sense that there is this kind of conversation taking place.
Yeah, sadly, I have to agree. Eunan, I just want to thank you for the correspondence from GSK. It was really very revealing tonight. Thanks a lot for that.
No problem, John.
Great. And a bit of a somber show, but I mean, a very interesting, fascinating, and absorbing. Would you agree, Breda? Did you learn?
Absolutely. I love learning from the two boys.
Yeah, I know.
I'd have
I
learned
know.
it from you three.
Well, not from me, certainly. Union, Breda, Frank, thank you so much, and hopefully see you all next week.
Thanks a lot,
Indeed, yeah.
John.
Okay,
Thanks
all
a
the
lot.
best.
Right,
Bye-bye.